All right, we're back on the record. No more interruptions. I'm done. I have my decision. I'm going to read it. I'm not making any orders today. And there's been discussion about Mr. Tashima involved. I've disclosed. In fact, that hearing after the telephone call occurred, I've commented on the fact that Mr. Tashima is my direct ecclesiastical leader. That's created some discomfort for me personally. He's never, and I reiterate, never communicated with me directly about the case. But the inferences obviously are clear. I understand that the plaintiff would look at that and question. Any logical, rational human being would look at that and wonder, I wonder what's going on with Judge Duckworth's direct ecclesiastical leader, now the CFO of Mr. Ansell's company. And efforts, to be clear, to influence me go beyond what's been stated. I want to be clear about that. And I certainly find myself in a position where I have become a witness, and that affects how I'm going to proceed today. I asked specific questions to get information about the specific crap, using Mr. Sanson's term, that I'll rely on throughout my decision, to determine exactly what had been communicated. Again, recognizing this is a sealed file, there are confidentiality orders that Mr. Ansell insisted on. If there are no specific facts, and I essentially offered the opportunity to finish the conversation that should have been on the record at the very beginning, then the only possible purpose of that communication with the court was not to provide information, clearly, because Mr. Sanson's indicating he had no information to convey to me. The only possible purpose then of that call was to influence and intimidate the court through a corrupt, out-of-court communication. I talked about earlier about whether or not there's any reason to keep this matter sealed under the shroud of secrecy. Sealing is not for me. It's not for the court. I'd rather complete transparency, and that's why I've allowed individuals into the courtroom. It makes no difference to me. We accommodate litigants routinely when they ask for a closed hearing. We'll clear the courtroom because I understand the fact that oftentimes these are private matters that individuals don't like thrown about in front of the general public. And so there are accommodations that are made. But as a general matter, this process should be completely transparent. I have nothing to hide. I find that there has been an effort to influence this court outside of the four walls of this courtroom. And given these influences, I find that complete transparency of these proceedings is in the public interest to maintain confidence in the judicial system. Based on these findings, this court orders that the order sealing the file is set aside as contrary to the public interest in the administration of justice. Further, the confidentiality order should be set aside as an order enforced through the court's contempt powers. To be clear, to the extent the parties have entered into any confidentiality agreements, it is a matter of contract law, and my order today does not alter contractual agreements of the parties. Rather, my order specifically relates to the contempt powers of the court. Mr. Sanson argues that his organization exposes public corruption and injustice. Further, despite the fact that Mr. Ansell designated Mr. Sanson as his witness, Mr. Sanson states with emphasis that neither he nor his organization, quote, have anything to do with this case. To reiterate for the record, Mr. Sanson has intentionally interjected himself into this matter by communicating with me outside of court. In May 2017, this court, sua sponte, scheduled a hearing after receiving communications outside of court that were attempts to influence the court in this case. For sake of transparency, I scheduled the hearing immediately to disclose on the record the nature of those communications. At the May 17, 2017 hearing, I stated for the record that within the past week I received communication from Mr. Sanson requesting that I call him. Over the past 9 years, and I related this at the hearing, and it's been quoted, I've spoken with Mr. Sanson on occasion, appeared on his internet program on one occasion, and have chatted with him at various functions. I've been told that from time to time he has written scathing materials about colleagues. I even heard recently, at that time in May, that he had declared war on the family court, and I mentioned that to him in jest that the last time I saw him. And again, this is dating back to my May statement. Although our communications are neither routine or common, they have been cordial and never involved a pending matter before me. Thus, I had no reason to believe that this request to talk to me would be any different. Our telephone conversation began with Mr. Sanson telling me, as he had told me before, that he thought I should be the presiding judge. He's told me that a number of different times. It's hard to believe within a matter of 24 hours, injustice is rampant. It's duplicitous. Then, without any prompting or specific question, Mr. Sanson asked me, not in answer to any question, he asked a question, why do you allow Mr. Willick to get away with so much crap in Doug Ansell's case? Immediately shocked beyond belief that a pending case was even brought up by someone I trusted knew better, I immediately told Mr. Sanson that I could not talk about the case, and I ended the call. For sake of completeness, for the record, Mr. Sanson's telephone records and my telephone records will confirm the following in terms of text messages and calls. On May 11th, and these dates are important, May 11th at 8:20 p.m., Mr. Sanson texted, "Judge, I need to speak to you." Close quote. On May 12th at 6:52 a.m., I texted in response, quote, "What do you need to talk about?" That was my question. What do you need to talk about? Close quote. To which Mr. Sanson responded on May 12th at 9:29 a.m., quote, "Call me at your convenience or we can grab a cup of tea," close quote. Thereafter, I called Mr. Sanson, again, unsuspecting of what was going to be discussed. On May 13th was the date of the telephone call. Again, the call began with pleasantries, "I think you should be the presiding judge," and then without any prompting, the question was posed as to why I allowed Mr. Willick to get away with so much crap in Doug Ansell's case. Immediately after the call ended, I texted Mr. Sanson the following, quote, "Please do not ever talk to me again about a pending case before me. I hold you in higher esteem than that. I'm sorry to end the call so abruptly. My integrity means too much to me than to be influenced by others outside of the courtroom, and it shakes the very core of our system when anyone communicates with a judicial officer in this fashion. It simply cannot happen. I know that you know that, and I have always trusted your judgment in that regard," close quote. Mr. Sanson's immediate text response reads, quote, "You asked me a question because of our relationship. I gave you my honest answer. So you can understand what direction we are headed," close quote. Now, in his omnibus supplemental declaration, Mr. Sanson alleges that on May 11th, he was, quote, "court monitoring various family courtrooms, including that of Judge Duckworth." Again, that date becomes very important, May 11th. When Mr. Sanson says that he was court monitoring, what he means he was calling and recruiting disgruntled litigants without any regard for the truth. After all, why let the truth get in the way of a good story? True justice requires the participation of all parties involved in litigation. It is easy to form opinions when you just speak with one party. That's easy. Never getting the other side of the story. As Mr. Sanson conceded in this case, he doesn't check with the other party to ascertain if there's another side to the story that has been spoon-fed to him by the disgruntled litigant. He acknowledged he's never met Ms. Ansell, and although he proclaims to have no ill will towards her, he couldn't care less her views of the crap she perceives Mr. Ansell and Mr. Jones have engaged in this case.
I'd like to object to this entire colloquy, which is based on assumptions and is absolutely wrong. It's based on evidence not presented.
So you can make your record.
Lack of foundation.
I'm reading, basically reciting what Mr.
No,
Sanson
you're
stated.
interpreting that, saying he has
met.
not looked into the case, and that's not true.
Well, it's a sealed case. And there's
No, in general,
he does have information about the case, counsel?
What I'm saying is, in general, when he publishes articles, he does look into pleadings that are filed if they are open, and he does look into it. It is not true that he simply speaks to one party and then writes an article. That is absolutely not true.
Is he aware that Mr. Ansell was the prevailing party in the custody dispute? He asked for joint legal
Irrelevant. He doesn't know anything about this case.
Well, did he look into that? Did he know that of all the parties who were aggrieved of probably what most litigants would say was the most important issue, the most significant issue in the case, that plaintiff was the losing party? She didn't want joint legal, joint physical custody. That's what Mr. Ansell. So did he look into that? No, he didn't. I don't need an answer to that, counsel.
Will it, Your Honor?
So despite knowing the full facts of the case, Mr. Sanson declares that there has been an injustice, that I've allowed crap. To be clear, both parties clearly understand, given the long history of this matter, that they have engaged in, to borrow Mr. Sanson's term, crap during this case. I repeatedly have chastised both sides of engaging in a practice of hyperbole and exaggeration throughout this case. And both sides understand and clearly know that. Getting back to Mr. Sanson's sworn affidavit, he states under oath that during a break on the morning of May 11th, he spoke with me in my courtroom. He further states that under oath that I had asked him a question about how I was doing, as if that is something that's significant to me, that I should care about what the perception is outside of the courtroom. I acknowledge that there was an exchange about this war on family court. I don't recall anything else about the conversation, nor does my staff. What's important here is the timing. That's what's critical here, the timing of Mr. Sanson's declaration and the false narrative he attempts to perpetrate. He would like me and anyone who reads his declaration to believe that I initiated the dialogue with him on the morning of May 11th, the same day that the text message confirmed that he asked me to call him. He wants to create a false perception that the ultimate telephone call was somehow related to a question I posed on the same date as his initiating text message. In this way, he could justify in his mind that he was simply answering my question. Mr. Sanson's entire factual premise is a false narrative. In truth and fact, this entire narrative that his statement was connected to a question I asked and that somehow I initiated the entire conversation on May 11th is a factual impossibility. I was not even in court on May 11th, 2017. May 11th, if you look at your calendar, is a Thursday. Thursdays are my chamber calendar days. I never enter the courtroom. Thus, there was not an initiating conversation on the date that he initiated contact with me. Now, this is not a matter of, oops, I got the day wrong. The entire narrative is premised on the fact that Mr. Sanson's text message was in response to a question that I posed earlier the same day, and it didn't happen. That it was part of an ongoing conversation that I would have had a connection to or understood what was being asked. The reality is that the way he has described it is a factual impossibility. In fact, I had my staff check all the hearings that took place on the Monday, Tuesday, and Wednesday preceding the day in which Mr. Sanson claimed there was a conversation. And although any conversation would be off the record, look to see if Mr. Sanson was in the gallery at the beginning or conclusion of any of those hearings. And there was no indication. That's not something I verified myself. Mr. Sanson alleges that the FBI is investigating corruption in California's family courts. I'm not sure what the point of that statement is or if he's attempting to take credit for it. But this matter should be investigated. We should be doing that here. It is the height of hypocrisy to decry corruption and then engage in the very practice you claim to be attacking and shedding light on. Communication with a judicial officer about a specific case, inclusive with veiled threats, is corrupt. This is not about some injustice that has been perpetrated against Mr. Ansel and Department Q, as I'm sure Mr. Sanson may spin it. When I asked Mr. Sanson today about what is the crap, what is the injustice, he had nothing. The argument's not even plausible, as I indicated before, when Mr. Ansel, the aggrieved party where injustice has been committed, is the prevailing party on the most significant issue in this case, unless, as I'm coming to learn, the money's more important. And although I do believe that Mr. Sanson should appear for a deposition, although I do believe that the document, and I do also believe that the document request served by Mr. Willick is overbroad and should be narrowed, and I do believe that Ms. Ansel is entitled to receive records to confirm whether the communications are limited to what I have described. I've stated it on the record. I'm not ordering anything today. The suggestion that Mr. Sanson's out-of-court communication was merely an innocuous statement or was not significant enough to warrant a recusal is inaccurate and completely understates the gravity of what we are dealing with. As I stated then in May, and I reiterate now, attorneys are frequently referred to as officers of the court. As such, I believe you have a duty as officers of the court to assist the court to ensure the administration of justice without outside influence. Any attempt to influence or sway this court's decisions outside the four walls of this courtroom should be frightening to counsel and corrupts the administration of justice. It is important that everyone here understands the magnitude of what we are dealing with. This is more than just this case or this court. In 26 years of combined practice and sitting on the bench, I've never been exposed to anything like what's happened in this case. This is about outside interference in the administration of justice through intimidation, threats, and improper influence. This is an attack on our system of justice in which an individual seeks to remove the symbolic blindfold of Lady Justice. This matter should be investigated.
We have
contemplated for some time
all of this,
recusing myself from this matter. I treat very seriously my duty to sit. However, I must analyze whether the events that have happened impact my ability to maintain impartiality. The reality is that early in this case, Ms. Ansell alleged that Mr. Ansell would win at all costs, that he would try anything to influence this court. When I hear that testimony generally, and when I heard it from Ms. Ansell that day, I scoffed. Perhaps not openly, but when I hear that, it sounds so implausible that it was unbelievable. I scoffed at the notion. Interestingly, this all started after custody had been resolved, the most important issue. And again, I reiterate, an issue in which Mr. Ansell was the prevailing party. Yet, there have been efforts to influence me. Thus, any decision I make in any way that favors Mr. Ansell is perceived by Ms. Ansell as being influenced by something that has happened outside of this courtroom. This perception is understandable given everything that has happened, not just the facts I've referenced today. Similarly, Mr. Ansell may have the perception that because of the open disgust and disdain that I've expressed about these outside influences, that I'm overcompensating to counter Ms. Ansell's perception. This is unfair to both parties. I also face the reality that I now have become a witness to events that have transpired outside of court in light of Mr. Sanson's efforts to influence me. Because of this conflict, I do find that it is appropriate at this time that I recuse myself from this case. To the extent it is possible, and the only orders I'm making from this case today is unsealing this file so that it is available, because it's something that does need to be looked at and looked into. To the extent it is possible, I would recommend, not that that has necessarily any sway, the preference would be to have a senior judge try the issue to avoid any further efforts to influence another court. That's subject to random reassignment and whether the powers that be can coordinate having it heard in that fashion. I recognize there is a motion to continue that has been filed. That is not, obviously I'm not hearing that because I'm recusing myself from this matter at this time. And so those dates must necessarily be moved anyway. I'm not sure how that's going to impact it, how far out, but you'll receive notice from whatever court ultimately receives the case. Thank you for your comments.